Mr. Goff, you indicated you had 2 matters before the panel comes back.
Yes, Your Honor. Since we last broached the subject, I would note that an individual that matches the general height and build of Pastor Mark Baker, a local pastor, I believe in jury selection, he was referenced by one of the jurors or potential jurors as having had the Attorney General of Georgia, Chris Carr, as a guest at his church where this case was discussed. I saw what I believe was that young gentleman, a pillar of our community, I would add, in the back of the courtroom yesterday. And I can't say that I see him now, but I thought I saw him out in the hallway. I would also note it's unclear whether he is a member of the Community First Planning Commission, one of the 21 black pastors. Of course, that is not just black pastors. There are other white pastors who've been in and out of the courtroom. I believe yesterday afternoon, I could be mistaken because I've never had the pleasure to meet her personally, but I believe our local rabbi, a white female, who's also been active in the social justice movement here, for lack of a better word, was present in the back of the courtroom. Given the court's rulings, and I'm not questioning the rulings of the court, of course, we're unable to document who actually is in the back of the public gallery, in the back of the courtroom. But then this morning, I believe, as much as I'd like to see him, I regret the circumstances, the Honorable Right Reverend Jesse Jackson is here yet again in the back of the courtroom. And there has been no indication yet from the state or anyone else that he is actually here in a capacity as a minister, given his remote location from this area. I am, again, separately and independently from any of the prior motions for mistrial, moving for a mistrial in this case. Again, the developments of yesterday afternoon and today, in conjunction with all that has gone before, reasonably called into question whether the defendant Bryan can receive a fair trial in this matter, notwithstanding the best efforts of this court to ensure one. And we are therefore moving for, again, for a mistrial.
Anything from the remaining defendants?
We're not joining on mistrial, Your Honor, but I think that it's prudent to recognize the limitations that the court set for who will be sitting in these rows, and that we do have the overflow room for the general public. I think it's been made abundantly clear that the people who are joining the Arbery family are part of a larger conversation that is happening nationally, that has been funneled down into the community, and so they represent a national conversation that is for the conviction of the defendants. And for that reason, I think that they should not be present in the courtroom where the jury can see them and be reminded of the national conversation. That is an improper influence on the jury to the extent, and I'm sure that they would recognize throughout the course of their lives, that they have had this type of impact on communities nationally and locally. And for that reason, I think it's more prudent to have them join the public in the overflow public room so that the risk of influence isn't present. Thank you.
Greg McMichael joins Travis McMichael's motion.
That would be the remedy that we're seeking.
Anything from the state?
There's absolutely no evidence that these jurors are aware of any national conversation about the conviction of these defendants. So to say that this is having an influence on the jurors assumes facts absolutely not in evidence. The assumption that there's some improper influence because some people are sitting in the back of the courtroom, there's been no evidence of that. And we leave it to the discretion of the court, Your Honor.
All right. The court's denying the mistrial. I address Mr. Sheffield's point. During jury selection, these particular members of the panel, the entire panel, I should say, that was before the court over 3 weeks was extensively, I don't want to say examined because that makes them sound like witnesses, and I've equated that before, but they were asked quite a bit about their backgrounds as part of the vetting process for this jury. And in fact, a lot of that went further than this court may have thought necessary, but it did delve deeply into many beliefs that they have about what is going on in this community, as well as with regard to organizations such as Black Lives Matter and various other things. So that has been vetted through the court, and I'm comfortable that that process has resulted in a panel that is willing to listen to the evidence and only the evidence that is presented in this courtroom. I've already ruled upon the presence of certain individuals in the court. I'm not going to go back over that, but I'm denying the mistrial for the same reasons that I've done before. I will note that the court has put restrictions on what folks can actually wear in the courtroom. We're not doing any buttons or face masks or anything like that. Everybody is here complying with the court's orders. There is also a order in place that governs seating in the courtroom and seating in the overflow room. And as far as I'm concerned, that has been complied with. That's the court's order that I put in place about a week, maybe 2 weeks, could have been longer before the trial started, to help address some of the concerns that were voiced prior to trial. So since everybody's complying with this court's orders, and since the court is comfortable that we have a panel in place that will listen to the evidence that is presented and not be influenced by factors that may or may not be appearing in the courtroom, and I'll note, just so that it's clear, I believe that the Reverend Jackson is in the courtroom. With all due respect to whomever Mr. Goff was addressing before, I don't know who that is, but the court's position, I think, has been made clear. All right. Are we ready to get the panel?